Okay, so we have our second panel, which is titled Saying No to War. It's going to look at World War I, the Vietnam War, and conscientious objectors. And our panelists are Laura Weinrib, who is an assistant professor of law at the University of Chicago Law School, Aryeh Neier, who is president emeritus of the Open Society Foundations and who I learned a lot from last night. Samuel Walker, who's professor emeritus of criminal justice at the University of Nebraska, Omaha. Risa Goluboff, who is the John Allen Love Professor of Law at the University of Virginia. And to moderate is our own Hendrik Hartog, who we call Dirk, who is a professor of history. He's not technically with the Woodrow Wilson School, but we borrow him enough that he is an honorary member of the Woodrow Wilson School. So welcome, everyone.
Thank you very much. I hope in this case that we will have a lot of time for questions from the audience, so I'm going to try to keep this shorter and maybe slightly crisper. I have a metaphor I thought of for the conference. In 1982, I was on the only junket I've ever been on in Yugoslavia. This was a moment after Tito had died, before Yugoslavia no longer was Yugoslavia. And people were saying all the wildest things, and I kept saying, isn't there any censorship anymore or repression? And this one guy told me, well, you know, it's sort of like a screw. You know, the screw has been really tight, and then it was loosened a little bit right now. But the screw hole still remains. At any time, they can just tighten it. So we're in this moment here, in this room, where the screw has been unloosened, so we can speak. The question is whether it can all be tightened again. Anyway, I don't know if that metaphor works. Let it go. This is a panel that highlights the deep content of the archives that Dan Link has described. And I want to highlight three people who have been amazing researchers in the archives of the ACLU and used them for immeasurable purposes and produced wonderful, wonderful scholarship through them. So I want to suggest that this is a panel in the first place about American history through the archives of the ACLU, full stop. That is, it's not about the history of the ACLU, though we will learn lots about the history of the ACLU. It's about what one learns about American history. And the archives, as Dan Link has described, are not just a history of this organization. You can write American history of the 20th century through this archive. And it's a wonderful source, and lots of people should be using it. The files allow a kind of entry into almost every conflict and problem in American history from the 1920s to the present. So our panel has, as a reflection in part on what one can learn from the archives, I think a really interesting structure. That is, we're going to hear from three historians who deal with the history of civil liberties in the U.S., full stop again. It's not just about the ACLU, but who deal with the history of civil liberties and freedom, the history of freedom and repression in the United States. Sam Walker, who should be known to nearly all of you as the great historian of both of the institution and of the political culture of civil liberties. Lauren Weinrib, who is writing a highly revisionist account of the interconnections between labor history and civil liberties in America. And Risa Goluboff, who after producing a transformative study of civil rights before Brown, has now almost completed a history of policing and vagrancy law that promises to transform our understanding of the 1960s. Now, all of those are about periods of war and non-war. It's about the problem of what is war. And we will learn a lot from them. And then we get to hear from Aryeh Neier, who is in the archives in a different way than historians who are merely in the archives. One could almost say he is, in many cases, the archive. And he'll reflect on the history from the participants' point of view, which gives us a different opportunity. And then I would hope we will have time to open the discussion up to the audience and to all of us together. So, Sam, do you want to begin?
Sure, thank you. It's great to be here. It's been a great conference so far. But first, I want to follow up on Dan Link's comments earlier today after lunch. And the purpose of this conference is to highlight, the tremendous resources that are in the ACLU archives. I hope this is not the last such conference. And I would like to suggest future conferences on such things as the ACLU and race, the ACLU and labor, the whole history of censorship, a history of women's rights issues, reproductive rights. These are all very rich. The ACLU's played a major role for decades in all of them, and I hope there will be 4, 5, 6, a dozen future such conferences. Following up on Dirk's words, what do we learn from the ACLU archives? What I learned is that the World War I civil liberties crisis marked a watershed in American history. And the watershed is that it marked the birth of what I call the civil liberties era. The civil liberties era defined as the condition where civil liberties issues are permanent, ongoing, contested issues in law, in politics, and American culture. It hasn't stopped. It continues today. Just look at the headlines and the ongoing news issues. Now, it is different because than previous periods because there were civil liberties crises. Obviously, the Alien and Sedition Act crisis, 1798, Lincoln's suspension of habeas corpus, but none of those issues stuck and became permanent, ongoing, contested issues, and didn't expand and grow as the whole issues of civil liberties have in following 1917. So, from this perspective, the pivotal moment is the night of April 17th, 1917. Woodrow Wilson appeared before Congress to ask for a declaration of war, and he famously called for a war to make the world safe for democracy. We know how well that worked out. But few people have noticed what he said 3 paragraphs later, when he said, if there is disloyalty, it will be met with a stern hand of repression. And repression there was. And so that is really, I think, the first marker, I have several, of the beginnings of this new era. It's worth pointing out that while he spoke, over at the White House, Alice Paul was leading a group of suffragists demanding the suffrage amendment for women in New York City. Roger Baldwin had just arrived. He was probably meeting with Bristol Eastman that night, and how are we going to deal with the coming draft law and the rights of conscientious objectors? I don't think that at that point they understood the suppression of free speech that was coming. So the night of April 2nd, 1917, a second marker would be November 18th, 1919, the Abrams decision, in which, from my perspective, Holmes's dissent launched a debate over the role of the First Amendment in American democracy. That's a debate that has continued ever since and will continue further. A third marker is January 19th, 1920, which was the first official executive board meeting of this brand new ACLU. And that marked the beginning of an organization that was dedicated to the continuing fight for civil liberties. It is true, the Free Speech League existed beforehand. It had done a couple of cases, but it vanished in the crisis of World War I. And so January 19th, 1920 is really the major event. Now we can understand, I think, a critical point about this new era through the lens of the person of Roger Baldwin. Because part of this new era was a split within progressive thinking of those people who were self-styled progressive social reformers. Roger Baldwin was a very prominent pre-war progressive, national reputation. He was the co-author of the book, the only book on juvenile courts, a major progressive reform. And his view was essentially a very optimistic one of the future. Intelligent people with the right values, people of goodwill, using the democratic process, would take care of the various social problems. It would address the various problems of American society, and social problems, economic problems, and society would progress. When war came, that optimistic vision was shattered. For the very first months in 1917, he was negotiating with the War Department. Fred Keppel, former dean at Columbia University, was his contact person. And again, this view that we are people of like-minded, we're social reformers, we're progressives, we understand each other, we can work this out if we just talk it through. Well, pretty soon, by early 1918, the military intelligence section is spying on Baldwin, and at some point, Keppel severs the relations. And if you read, his letters, back to him, it's really kind of pathetic. It's just embarrassing. You can't do this. I mean, really. And in his meetings with military intelligence section, one of the most embarrassing aspects in the full history of the ACLU, he provided them with information, including the membership list, including the contributors list, including the list of lawyers, which we very shortly found out exposed them to possible prosecution under the Espionage Act. But at this point, and I think this is really the critical moment, he's still mostly a progressive. He's not yet a full-blown civil libertarian. And he thinks, yes, we can work this spread. We can work there. Military intelligence, we can work this out. We just understand each other, and I'm going to be forthcoming with you, and you're supposed to be forthcoming with me. Well, that certainly ended on August 30th, 1918, when the Justice Department raided the Civil Liberties Bureau offices and seized all its records. And in the standard accounts, Baldwin was apparently just so discombobulated. He was just running around the office, just completely unsettled. And I think it's often presented as sort of a pathetic picture, but you have to understand that his world had been shattered. This optimistic, progressive faith that we can, reasonable people and good-hearted, well-intentioned people, we can work things out, not true. And so, from those events forward, he then became a more, what we consider a full-fledged civil liberties person, where there's an immediate and instinctive skepticism about what government is going to do and what government might do, and permanently on guard. And so from those events, from between April 1917 and August 30th, 1918, that is the moment of the birth of what is a new era in American life, distinct from previous eras.
Can I just say one thing? I mean, as I was listening to it, I was just thinking, part of what he didn't believe in was the Constitution as a transcendent. I mean, what we forget is that very few progressives thought of the Constitution as a problem in American life. Something controlled by capital, something that benefited capital. They'd all read Charles Beard.
Absolutely.
And so that part of the transformation that becomes the 20th century is the transformation to the world where the ACLU can call itself the Lawyers for the Constitution and imagine that as a positive.
Well, that's a great segue to what I want to talk about, because it's very much the project I'm immersed in right now, which is recovering this history of the civil liberties movement and the modern understanding of civil liberties in America as a concept that was sort of framed against the state, enforced by the courts, and as a constitutional right. And none of those were attributes that previous incarnations of civil liberties really had. So what I want to do actually with my time here is a little bit of sort of reconstructing substantively this World War I emergence of the ACLU's program in civil liberties, and also reflect a little bit about what the archives can teach us about that project. And those two pieces are obviously very linked. So I share almost all of Sam's views about this period, except for that I want to emphasize a piece that's often missing in these stories of what the World War I National Civil Liberties Bureau, NCLB, precursor to the ACLU, was about. And that is the labor part of the story, and in particular, a commitment to what they would call, borrowing from language of the industrial workers of the world, the IWW, the right of agitation. And the right of agitation for them was a right to picket, to boycott, to strike, to engage in what the courts at that time regarded as coercive economic activity, but what the ACLU was increasingly coming to define as core to civil liberties. Those are obviously issues that we haven't heard much about today, that are not very familiar, so it's going to take a little bit of sort of backing up. As Dirk was just mentioning, prior to World War I, the First Amendment claims almost never succeeded in the federal courts. Now, that didn't mean that progressives didn't have a commitment to something like what we today think of as free speech. They thought that as a policy matter, it was really important to debate these issues. This is very much what Susan Herman was talking about with respect to Frankfurter. There was a sense that as a policy matter, it was a good idea to tolerate dissent, both because it would air disfavored views that might become accepted, and also because it would sort of diffuse radical tendencies. But what there wasn't was a concept of civil liberties as a check on state action. These were sort of, the government might by its own hand afford certain protections to certain people. It might decline to prosecute in certain cases. Police commissioners might exercise discretion. But it wasn't about, once a majoritarian decision had been made, this was not a First Amendment right idea as something asserted against it. Okay, and then conservatives actually also had a concept of civil liberties prior to World War I, but they stopped at the right of radicals to speak or dissent, which they, the big opposition was what they called liberty versus license, and it didn't encompass anything that was seen to be potentially subversive. Okay, so there's no civil liberties consensus before the war, I agree, and so the question really is, where did that come from? I think the typical explanation is that the wartime repression was so great that there was a backlash against it. You get the report on the illegal practices of the Department of Justice. There's some truth to this, but it turns out actually that the story is much more gradual than this. Actually, after World War I, most of the efforts to sort of rein in the excesses of the administration were still on the sort of policy type grounds that had existed before the war. There still was not, notwithstanding the Holmes and Brandeis dissents, very little sense of a strong First Amendment still. Within a couple of decades, all of that would change. There would actually be a broad-based consensus across the political spectrum on behalf of a strong First Amendment that could operate against the state. And this is a very complicated story with a lot of moving pieces. It involves institution building, it involves organizational politics, it involves conversations with government. Basically, over the course of the 1920s, I'm just going to preview this, the ACLU would work both with progressives and with conservatives to bring about a consensus on behalf of civil liberties. The approach it ended up taking involved a lot of trade-offs, trade-offs that we can sort of think of today in Citizens United terms. The ACLU actually fought with its New Deal allies about whether to trust the state to advance socioeconomic rights, or whether the state always sort of had always laid the danger of state overstepping, and it went the overstepping route, and so it turned away from a lot of programs that were offered by the New Deal. It teamed up with the American Bar Association and even former American Liberty Leaguers to defend the court as an institution, despite its sort of Lochner-era tarnish, as an institution that could protect against the state. That's the trajectory in a nutshell. Right now I want to just talk very briefly about two of the NCLB's agenda items and sort of formative experience during the war period. So the first I don't have to say much about because Sam just talked a lot about it, is the defense of conscientious objectors. And this was a direct outcrop of the American Union Against Militarism, its precursor organization, which was a pacifist organization. Defending conscientious objectors was a way of continuing the anti-war agenda once war was inevitable. What's interesting about what the ACLU does with respect to the conscientious objectors, unlike, for example, Frankfurter and others within the administration, is the NCLB wanted to defend what it called political objectors. Political objectors were the people who weren't opposed to all wars on religious grounds. They didn't have sympathy along these lines. They were opposed specifically to World War I as a matter of conscience. They were willing to engage, and this is because, often this was what we're talking about here is socialists, from whom many early ACLU supporters came. They were opposed to World War I because it was seen as an industrial war, a war of capital. And they wanted to defend the right of objectors who were willing to serve in a class war, but not in World War I. Needless to say, that was a very unpopular view within the administration. They didn't manage to get traction on this issue, and over time, their relationship with the government sort of collapsed. Now, the conscientious objectors issues were central, I think, to the lessons that the NCLB learned during World War I, but actually I think they were less important than the lessons they learned from their defense of another group who, in the earlier slide presentation that Susan Herman shared with us, you saw a lot of images that were actually about the IWW. One of the most important things the NCLB did during World War I was to defend the IWW against basically being prosecuted out of existence. The entire leadership, and I should say defend unsuccessfully. Now, they didn't defend them in court. They defended them through propaganda. They defended them through other means. Basically, they were extremely committed to defending this group, and that was for a couple of reasons. First, it was because the threat here was the federal government. It was federal agents who were seizing IWW property and documents. It was the Postal Service that was preventing the IWW from circulating its materials and advancing its agenda. What was really striking here is the failure, and again, Sam alluded to this, the failure of administrative methods. So as good progressives, it had always worked in the past to basically get concessions and to get the war, their goal was maybe to transfer this from the Department of Justice to the Labor Department, which they regarded as more sympathetic. All of that fails. Basically, there's a complete breakdown of these initially successful approaches that have to do with what we might now think of as administrative constitutionalism. Because of a combination of their failures to work through official channels on both of these issues, the NCLB moved away from its earlier progressive-inspired approaches. But there was a more sort of fundamental theoretical implication of this wartime experience, and that was that the NCLB leadership actually came to believe much of what the IWW had been advocating. And in particular, it came to believe its theory of direct action. It came to believe that basically the state could not be trusted to provide for to advance substantive goals. And so the goal was to keep the state out of a private power struggle. And before it ever turns to the courts as its primary venue, this is the lesson that the ACLU learned, basically. And it advances a theory of a right of agitation that's very much like what the IWW was claiming in the economic realm. So, and I should, there's the leadership of the ACLU basically committed its resources to advancing the substantive goals of the IWW. This is when Baldwin went through his most radical phase. He actually, during his year in prison for refusal to serve in the military, he actually joined the IWW. He was dissuaded from making that his lifelong commitment by Bill Haywood and others because they thought he could do more good in other ways, and as a result, he decides to turn the NCLB into the ACLU. Okay, so let me just highlight what the early ACLU was actually committed to. So memorandum on the reorganization of the work for civil liberty put the goals this way. We are frankly partisans of labor in the present struggle. Our place, they said, is in the fight. This is not, we're committed to the views of everyone. This is, we are frankly partisans of labor in the present struggle. So how did they intend to assist labor? Not through negotiations and political pressure, not through constitutional litigation, but rather through direct action. They wanted to go out into the coal fields. They were picketing. They were in the fields. This was not just propaganda, although that was part of it. This was about actually engaging in strikes. Okay, I'm going on too long. I'll just say, this is obviously an unfamiliar vision of civil liberties and of the ACLU. It's not premised on individual rights, nor is it premised on progressive values like the marketplace of ideas or democratic deliberation. It was also, in its initial form, a sort of short-lived view. So during 1920 and 21, they go out, they do this picketing, it fails. But in fundamental ways, it really shaped. You continue to hear the phrase right of agitation, and it takes various forms through World War II, continued to shape its concept of what the civil liberties agenda should be doing. So the last thing I wanted to do just was to respond to what the surprises were in the archives and what we can learn from archival research about the history of the ACLU and about civil liberties. We'll start with just a general point, which is that civil liberties has been something of a holdout for doctrinal history. There has been a continued focus on the seminal First Amendment cases, and court cases, that is, Supreme Court cases. And much of the research extends out from there. So people see these cases and then they look to the actors who are involved in these cases. When you go into the archives and look at what the ACLU cares about, you realize that that's actually a very minimal part of their agenda during this period. They're hardly, during some of these periods they're thinking about these cases, but they're thinking a lot harder and more intensely about other issues. One of the biggest mysteries for me has been about why the labor history of the civil liberties movement has been forgotten. To give one example of this, Anthony Romero mentioned that the organization's involvement in lynching during the early 1920s, and that's absolutely true. They were involved in anti-lynching work. If you read the pamphlets on lynching, it says that the solution to the problem of lynching is the class struggle, and that the race problem is a function of the class problem. This sort of narrative has been completely lost. So the question is why? How could something that was so central have been forgotten? The first part, I think, became painfully clear to me when I started my project in the archives, which is that we've lost a lot of the vocabulary that these people had with respect to to labor. They shared a common understanding of how central the labor problem was. That's just completely disappeared. This extends to the names and beliefs of the figures that they were cooperating with, the organizations they were cooperating with. I've often referred to my work in the ACLU archives as a sort of hubs and spokes approach, and you start with the ACLU and move outward, but you have to be willing to sort of follow outward to where it goes and not have preconceptions. The next thing, the last thing I'll say is about sort of a conscious reconstruction of this history. And the ACLU was acutely aware of the unpopularity of its substantive agenda during this period and afterwards. So, from the beginning, Roger Baldwin worked hard to bring mainstream progressives and conservatives on board with the civil liberties approach, with the civil liberties agenda. We run into the attribution problem here, because the National Committee often did genuinely believe things that seem a lot more like contemporary civil liberties concerns. But if I suspect that the National Committee then, I should say, I know that the National Committee then, which it sounds like is still true now, actually had very little to do with the agenda of the organization, particularly during the 1920s. So there's been a line from the beginning of the ACLU, which is the reason we defend so many radicals and leftists is because those are the people who are suppressed. That was true. There were contentious debates within the ACLU over whether to defend Nazis, to defend the KKK, to defend the right of employers to free speech. On all of those issues, they eventually came to defend the neutral position. But there was a conscious element to this. And beneath the surface, there was, in fact, a substantive agenda. And I'm always worried about the way that finding will be manipulated in the popular imagination. I want to say it was not unique to the ACLU. So when the ABA came on board with the Civil Liberties Project in the 1930s, it said, we need to do exactly what the ACLU did. We don't want to defend just the rights of employers to free speech or to lobby government. We want to also defend the right of radicals or of the CIO to picket in Jersey City. But there is a real question about how these things, whether these things have been sort of consciously forgotten, and I'd be curious to hear reflections on whether that's the case.
Risa? Thank you. Thank you for having me. It's great to be here. A lot of what I'm going to say is going to pick up on various things that Laura said, which probably shouldn't be a surprise. I'm going to say Dirk Hartog was both of our dissertation advisors, so we are intellectual siblings. So I work in a different period. I have different things to say, but a lot of it will pick up on what Laura said. So I like to complete the assignment, and I found the assignment today difficult because it seemed like there were two different assignments. I can't see the people over here. It seemed like there were two different assignments. So one assignment is to talk about civil liberties in wartime, and the other is to celebrate the ACLU archives. And I really had trouble thinking about these two assignments together. So I'm going to talk about both of them slightly separately, but they'll come together at various points. So first, and more briefly, I'll talk about civil liberties in wartime. So a lot of our conversations thus far have been about specific governmental programs in response to threats to national security and the civil liberties suppression that has been a part of those governmental responses. But as Dirk mentioned, I'm in the midst of a project about vagrancy laws, and what I see when I look at the suppression of civil liberties is the deployment of everyday low-level criminal law for the suppression of civil liberties during wartime. So for those of you not that familiar with vagrancy laws, my hope is that once my book does come out, everyone will be more familiar with vagrancy laws. They came to this country from England with the colonists. They proliferated everywhere. They were used by pretty much every police department in every city and state in the country. They made it criminal to be a certain type of person, to be idle and poor, to wander about with no apparent purpose, to be immoral or profligate, to be a common drunk, a common prostitute, lewd, and lascivious. These laws were different from most American laws that are based on conduct. If you commit this conduct, you violated the law. These made it a crime to be a certain kind of person. They were called status laws. And for centuries, they were used against all kinds of people, not just poor people. So if you do have a conception of vagrancy, you think vagrancy laws regulate vagrants. These laws were not only used against poor people, they were used against religious minorities, racial minorities, cultural nonconformists, political dissidents, who we're going to talk about more in a minute. They were used, and the thing that was brilliant, the IWW, a lot of the IWW arrests were for vagrancy. One of the things that was so brilliant about these laws was that they were broad, they were flexible, you could find probable cause to arrest somebody under them virtually for no reason at all, and the police never had to go back to the legislature to ask for authority, right? These laws gave virtually blanket and flexible authority to law enforcement officers for a very, very long time. And they were usually prosecuted in low-level courts. They had no transcripts, they had no procedures. There are stories about these courts where 50 people are brought into a courtroom, told to stand up. The judge looks around, picks out one who looks particularly clean, says, "Do you have a job?" That person says yes. They say, "Fine, you're fine." The others, 60 days in the workhouse, a minute and a half, 50 people. So these laws were incredibly useful. So they get deployed when any new threat comes along. During wartime, political dissidents pose such a threat. So I'm just going to mention two people who I've come across and I talk about in my book, and they're then also going to serve as examples in the second half of what I have to say. So the first one is a guy named Isidor Edelman. He was a communist in 1940s, late 1940s, early 1950s Los Angeles. Actually, he was kicked out of the Communist Party because he was such a troublemaker. He got kicked out of virtually every organization I have found him to be a member of. If his name rings a bell for any of you, he did serve as a next friend for the Rosenbergs for one of their emergency stays. He did not know them. People were very annoyed by people found him an annoying guy. So he was a soapbox orator. He actually commuted across Los Angeles by bus every day to Pershing Square, where there are a lot of soapbox orators, to talk about communism, essentially. And there were a bunch of folks who were self-identified as fascists, some of them, who heckled him and harassed him, and the police arrested him again and again and again. They finally arrested him one time for vagrancy, and the justification for the vagrancy charge was that he was immoral and dissolute. And he was immoral and dissolute because he had previously been convicted of crimes. So if you've been convicted of crimes, like standing on a concrete park bench to make a speech, that was called defacement of the park bench. He'd been convicted of that, so now he was a vagrant. His case goes up to the Supreme Court, which in 1953 hears argument in the case and then dismisses it as improvidently granted in the first of about a dozen cases where the court takes vagrancy case, doesn't know what to do with it, gets rid of it in some way or another, and then moves on. It takes them about 20 years. They finally strike down vagrancy laws in 1971 and 1972. So one of the cases that they used to strike down a loitering law, which is very, I think of vagrancy, loitering, and suspicious persons laws altogether. I can talk about why if you want. So there's a case involving a guy named Dennis Coates, who is an Antioch law student, undergraduate student. He was called dirty and unkempt. He was involved in a Vietnam War protest in Cincinnati. Cincinnati had a law that criminalized loitering by 3 or more people if they were annoying to passersby. This was the standard, if they were annoying to passersby. Now, by the accounts in the record, which were slim, Coates was pretty annoying. They stopped traffic. They interfered with a federal building. But his case goes out of the Supreme Court, and this is the first case, actually, in which the Supreme Court strikes down a vagrancy or loitering law at all. I could go on. There are many other stories, but the point I just would like you to take away from this is it doesn't always take a brand new Patriot Act or surveillance program for the government to suppress dissidents, and vagrancy and loitering laws aren't the only ones. Breach of the peace laws, disorderly conduct laws, there are a lot. loitering and vagrancy were particularly useful because they require no conduct at all in order for a person to be arrested. So this brings me to my second half, which is about the archives. And Edelman and Coates will come back in a little bit. So when I started this project, my first project, as Dirk mentioned, was about civil rights before the 1940s, and particularly the economic aspects of civil rights. And I kept coming across, I was studying involuntary servitude of African Americans in the 1940s South. You can pause there and think, really, was that? Yes, okay. So one of the laws that was used to keep people in involuntary servitude were vagrancy laws. And I had in the back of my head a case that I had read in criminal law in law school, which is a very common law school criminal law or criminal procedure case, Papa Christou v. City of Jacksonville from 1972. This is a case that strikes down a traditional vagrancy law for the first time. Coates was loitering. This is vagrancy. There was also a 1971 suspicious persons case. And in that case, 4 of the 8 defendants were a interracial double date, 2 white women, 2 black men on a double date in Jacksonville, Florida in 1969. They are in a car driving from dinner to a nightclub. They get stopped and arrested for vagrancy by prowling by auto. That was not actually one of the categories of vagrant in the Jacksonville Ordinance, which had many categories, including rogues and vagabonds, but that was not one. So that's the case that goes into the court, and I thought to myself, vagrancy laws are being used in racial regulation, but in very different ways. In the 1940s, they're being used to regulate African Americans who refuse work in the plantations because they have better economic opportunities and they're being forced back. And in the 1960s, they're being used against people who are crossing racial sexual lines and taboos. So I started looking around at what else there was, and I started the project from 2 focal points. 1, the social history of the uses of vagrancy laws, and 2, Supreme Court cases involving vagrancy laws. And I really liked Laura's hub and spokes analogy because I started with all the spokes. I did not know the ACLU was a hub for a very long time into my project. And that's partially because of something that Susan was talking about this morning. There are cases where the lawyers are affiliated with the ACLU, but it doesn't say ACLU on the briefs. And so after doing quite a lot of digging, I finally realized the work that the ACLU was doing. And one of the cases where that became really clear was in this Edelman v. California case. So Edelman loses at the trial court and at the appeals court, and they decide, the California lawyers, Al Weirin, he's come up once before, he was one of the lawyers who did the Japanese internment cases, they decide that they're not going to argue at the Supreme Court. They're in Los Angeles, they don't have money, and so Herbert Monty Levy on the ACLU national staff gets wind of this and is very upset and really wants this case to be argued. And so he gets Emmanuel Redfield, who is in New York and affiliated with the ACLU, a member of our New York board. I'm not that yet, but here, a member of our New York board has agreed to argue the case. Now, here's the thing. It's so late in the day, they do not have a copy of the briefs. So he writes to Irving Furman in their Washington office. He says, "It is very possible that Manny might not see the papers of both parties before he arrives in Washington. I would suggest that it might be valuable if you could examine the briefs in the clerk's office before he arrives and furnish him with any additional ideas or rebuttals on the respondent's position that your nimble brain conjure up." So here's a guy. He has nothing to do with this case. The case is in Los Angeles. He's in New York. He comes in. The central office in New York organizes this whole thing, gets the Washington office guy to go to the clerk's office of the Supreme Court and read the briefs so that when Emmanuel Redfield comes in, he can be briefed on the case. So that is precisely the kind of thing that the national office does. But then if you dig more, what I learned is Emmanuel Redfield had actually been fighting vagrancy laws in New York since 1950. That's 3 years before this moment. Since 1950, he continues to do that, and in 1967, so that's some 17 years later, succeeds in getting struck down the New York vagrancy law in a case called Fenster v. Leary. And so as I go through, I start to put together all of these lawyers all across the country who are discovering that vagrancy laws are affecting people that they care about, and people are coming to them with vagrancy cases. I want to move on from there, but the last thing I'll say is to bring Coates back in, not all of the cases. So this didn't start out as a story about the ACLU, and this still isn't a story about the ACLU, but it is a story in which the ACLU turns out to be a hub. And it turns out to be a hub not because this is a centralized litigation effort on behalf of the ACLU. I think most of us think that constitutional change happens because an organization like the NAACP or the ACLU decides there's a problem and goes forth and fixes it. The vagrancy law challenge, which created, as I said, some dozen Supreme Court cases and, more importantly, hundreds and hundreds of lower court cases between the mid-1950s and the mid-1970s, started out because of people's lived experience of being arrested for vagrancy laws and of going to lawyers who took their cases and then started to look for resources in how to attack these cases. And the ACLU provided these resources. So I learned there are a whole spate of hippie cases where hippies in 1968 are getting arrested in their own homes for vagrancy laws. Police officers come to the house, come in the house, arrest them for vagrancy. And it turns out that the lawyers who pursue these cases are all affiliated with the ACLU. It's the only ACLU lawyer in Boulder, Colorado. It's the only ACLU lawyer in Amarillo, Texas. I mean, they are all affiliated, and they're being called the hippie lawyers. And some of them are being called that because they're kind of hippies, and some of them are being called that because they're representing the hippies. But it turns out they are sharing the briefs through Mel Wolf and other people in the national office. So the two conclusions that well, maybe there are three. The three conclusions that I want to draw from that are, one, the point that, I might not have three, we'll see. The point that Laura made about the hub and the spokes, I want to put together with the point that Dirk made about the ACLU archive being really an archive of American history. So I've been on a tear lately about what constitutional history is. I've been teaching this class for a few years, and constitutional history used to be pretty clear. It was the history of the Supreme Court and Supreme Court cases. And that hasn't been the case for some time, at least since Dirk wrote an article in 1987 about it. But Dirk has always been very coy about what constitutional history is, so I've had to refigure it out. I've had to recreate the wheel, maybe we would say. No one got the hub spokes? Okay. For myself. But the ideas of the new constitutional history, which I think Laura and I both think of ourselves as practicing in, don't start with the Supreme Court, and they don't end with the Supreme Court. And Dirk said the other day to me, I don't know, constitutional history, it's just American history with courts. And if you think about the first piece that I wrote, actually, about my vagrancy work was called Dispatch from the Supreme Court Archives. And I had done a bunch of research in the papers of various Supreme Court justices, and I wrote an article about what I found, which was of interest to constitutional law scholars. And I was thinking today about, well, what remarks I would have to say would be the dispatch from the ACLU archives, right? That's what this is. And the difference between the two dispatches is enormous. And what you find in the Supreme Court archives, number one, the Supreme Court archives are tantalizing because they are not the Supreme Court archives. They're the archives of various individual justices. A lot of them are at the Library of Congress, but they're all over. They're tantalizing. The Supreme Court gives you a ready-made narrative. There are these 9 people, they get a case, they decide a case, they get a series of cases, they decide a series of cases. But when you go to those archives and when you think about the court, the scope is very narrow. What people have done before those cases get to the court is distill a legal question. And what the justices are involved in is answering that legal question, and they'll bring in things from the outside, and it's possible to see the outside world in their papers and in those cases and to move outward from there. But if you can contrast that to the ACLU archives, the ACLU archives are American history, and then you can see how lived experience, social movement experience gets refracted through that hub and ends up sometimes in the courts, sometimes not in the courts, looking the way it does. And so it really seems to me that when we think about the new constitutional history and the kinds of sources that are appropriate to use, the ACLU archives are really the archetype of the kinds of sources that I think people should be looking at. So the last thing that I want to say, thinking about these spokes in this hub, goes back to this image that we have of how litigation happens. And because this is, my book is a history of the 60s, I think of it in these terms. The image that we usually have is of a 1950s prom, or what I think of as a 1950s prom. You know the guest list, you know the time and the place, you have a sense of what you're supposed to wear, you know the duration, it's all pretty pre-planned. The vagrancy law challenge was kind of like a 1960s happening, right? It just sprung up. Everybody was invited. What happened, happened. You know, shit went down. But somebody did decide to host it, right? And people did get the word out. And the ACLU plays that role. And, you know, my book ultimately is a legal history of the 1960s, because virtually every social movement and reform movement of the era challenges vagrancy laws, because they come smack into them as they try to have a civil rights movement, as they try to live a countercultural life, as they try to protest the Vietnam War. Vagrancy laws impede them. And so this book is really using vagrancy laws as a window into the 1960s. But it really isn't possible unless you have an archive like the ACLU's that allows you, not necessarily, I'm still not telling the story of the ACLU, but it allows you to connect the dots, to see the spokes and the hub, to connect the sinews. And so I would say, in a push to use the archives, you shouldn't think if that wasn't an ACLU case, it's not going to be in there, or if it wasn't an ACLU issue, it's not. It's all in there. All right, I'll stop there.
Okay, look, I think the theory of this panel was that my role was to suggest the way in which the lived history inside the ACLU may provide a somewhat different take on what happened from what is provided by the archives. But since a couple of my fellow panelists spoke about the First World War period, and contrary to what some of you may think, I don't go back that far. I'm not really able to suggest what the contrast might be. I thought there might be some greater discussion of the Vietnam War period, and my tenure at the ACLU covered the entire Vietnam War period. I started work for the ACLU in 1963, and I left the ACLU in 1978. So the Vietnam War period falls within that span. And since that was the era that I was engaged, let me nevertheless talk about that era. I think the first thing to be said is that if you simply take the repressive measures that the government engaged in, they were pretty substantial, and you might have thought that they would have had a significant impact in repressing dissent. That is, there were quite a large number of people who were prosecuted in federal courts because they were not recognized as conscientious objectors. I think somewhere between 20 and 25,000 persons were prosecuted in federal courts on those grounds, and a few thousand of them served time in prison. There were also people who were prosecuted for resisting the draft, for burning draft cards, turning in draft cards. There were people who fled the country, went to Canada, went to Sweden during that period. There were people who were punitively reclassified in the draft. That is, they had taken part in demonstrations against the Vietnam War and against the draft, and their draft boards, as a result of that, reclassified them so that their call up for selective service would be expedited. And I don't know how many people all over the country were arrested for taking part in demonstrations against the war, but I think the figure probably goes into the hundreds of thousands. That is, there were mass arrests. Now, despite, and then of course perhaps the largest form of repression was the high level of political surveillance during that era. We talk about surveillance today. Actually, for someone who lived through that period, the surveillance today, while extremely extensive, doesn't seem anywhere near as repressive as what took place during that era, because it was surveillance by a large number of agencies of the federal government. Certainly the FBI was first on the list, but a typical example of FBI surveillance. There was a demonstration in Washington, took place in November 1969. It was an important demonstration against the war. An organization in New York City called the Fifth Avenue Peace Parade Committee chartered a large number of buses to transport people to Washington. And we got a call, I actually got the call, from a clerk at the bank where the Fifth Avenue Peace Parade Committee had its account, and the bank clerk said the FBI had come by to photograph all the checks of people who had reserved places on the buses so that they would know the names of the people who were going to take part in the demonstration in Washington, D.C. And that was characteristic of FBI surveillance. But for example, the U.S. Army got into the act. And the Army had more than 1,000 personnel who were assigned full-time for political surveillance during the Vietnam War era. And of course, the federal government political surveillance was dwarfed by the political surveillance of local police departments around the country. Every major city police department had its Red Squad. In New York City, it was BOSS, the Bureau of Special Services. They compiled files on more than 1 million people. In Chicago, they compiled files on 400,000 people. And they didn't just compile files. That is, when people applied for government jobs or licenses, those files were consulted. When private employers wanted to get access to that information, they easily got access. The typical way was that police would retire after 20 years with half pay. They would then go and become security personnel for private employers. And when people were being hired, the security officers would consult their colleagues in the police department. And if there were files on those people were denied jobs. So political surveillance wasn't just political surveillance. It had very real consequences for the people who were involved. Nevertheless, I would say that during the Vietnam War period, if the purpose of all of these activities was to repress dissent, it failed. That is, dissent was very lively during that period. And there surely were people who were individually intimidated. But the country as a whole was not intimidated by the repressive measures. And I think the ACLU role was very significant in that. I think another significant element is the historical timing. And that is the period of dissent against the war in Vietnam followed very hard on the heels of the Southern Civil Rights Movement and Northern engagement in the Southern Civil Rights Movement. And the kinds of young people who went south for the Freedom Summer of 1964 and the lawyers who went south during that period were very engaged in dealing with political dissent. One group that we were involved in creating was the Lawyers' Constitutional Defense Committee. And in the summer of 1964, we sent about 120 lawyers, almost all of them from large firms in northern cities to the south. And I would say the majority of those lawyers then came back to their home communities and left their practices with those large firms and became engaged in some fashion on a full-time basis in the defense of civil liberties. Lawyers who I hired at the New York Civil Liberties Union first and then later at the ACLU had been among the lawyers who had gone south during that period, and they found other ways of defending civil liberties as well. So the fact that the Vietnam War dissent came right on the heels of the Southern Civil Rights Movement was a factor. Another factor can't be discovered by looking at the court cases. Because we were so deeply involved in defending dissent, we learned how to do things that went far beyond what we could do actually in court. And I'll give you two examples of that. One of the attorneys I had on the staff when I directed the New York Civil Liberties Union, some of you know him, is Paul Chevigny. And Paul set up on his desk something called a moviola. And a moviola was a machine through which you could run movie tape. And we had made arrangements that where there were going to be demonstrations against the war, we would find offices in which we could have movie cameras to film what was going on so that we could see what was going on in the demonstration. And afterwards, if we needed to defend people, we would be able to use the movie film that we had. And we discovered something during that, and that is when the police had to make mass arrests, they didn't really know how to handle it. And so cops would grab people and they would hustle them into the police vans. And then later on, the person who would testify as the arresting officer was actually not somebody who was in any way involved in actually arresting the person. That is, the police officer who would testify was going to lie. He was going to say that he had conducted this arrest because so-and-so conduct had taken place. But the police who were assigned to testify were simply selected arbitrarily. They couldn't match the police officers who had actually made the arrest with the police officers who testified. And I remember one day in December 1967, we had about 600 arrests in demonstrations in New York City. And ultimately, of those 600 arrests, 2 people were actually convicted. We got all the others off. And we got all the others off by showing the district attorney the film that we had on the arrests and showed him that the officers who were prepared to testify against the people they said they had arrested had actually not conducted the arrest and were not present. Later on, May 15, 1971, there was a spring mobilization against the war in Washington, D.C. I think that was the date of the largest mass arrest in American history.
I think I was there.
Okay, about 15,000 people.
I'm pretty sure I was
About 15,000 people were arrested. The only thing the police could do was to take the people who were arrested to Robert F. Kennedy Memorial Stadium, and we figured out that the police would be walking around, taking people's identities, and arbitrarily assigning different police to say they were the arresting officers. And so we got lawyers into the stadium as this was taking place, and again, virtually no convictions out of the 15,000 people who were arrested. William Rehnquist had called it qualified martial law. John Mitchell, as Attorney General, had taken over the direction of this effort from the Washington, D.C. police, and we actually got damages for a significant number of the people who were arrested on May 15, 1971. So a practice like that, or understanding that, because of the deep involvement in mass arrests, was more important than any actual court decisions that we won. Another example of that sort of thing in which I was involved, and apparently I nearly got myself prosecuted by the federal government for this. There was also in 1967 an occasion when there were many demonstrations against the war simultaneously in New York City. It was the time that Martin Luther King came to speak at an anti-war demonstration and was denounced for mixing the issues of racial equality and opposition to the war. The New York Times editorially denounced him for that, and most people, or most respectable commentators, denounced him for that. But there was a particularly radical group that was going to be among the demonstrators, and they were going to burn their draft cards that day. It was a group of about 150, and the night before the burning of the draft cards, they assembled, and they asked me to speak to them about what the consequences would be of burning their draft cards. And in the course of speaking to them, I gave them a bit of information. I said to them that in all the draft card burning prosecutions with which I was familiar, the FBI had recovered a fragment of the burned draft card and had used that as part of the evidence in the prosecution. And that was actually quite important because who knew what these people were burning? Were they burning odd bits of paper? Were they burning photocopies of their draft cards? There wasn't any occasion when you actually had to present your draft card anyplace unless you wanted to buy a drink. But there was no use for this piece of paper, but burning it was a crime, and we had lost the case in the U.S. Supreme Court in which we challenged the constitutionality of making that a crime. Well, the next day, everybody who burned whatever piece of paper they burned it to a crisp. There was nothing left over. And so there was no possibility of prosecutions of any of the people who had taken part in that. The FBI, I subsequently discovered under the Freedom of Information Act, suggested to the U.S. Attorney's Office that I had engaged in obstruction of justice, but the U.S. Attorney's Office declined to prosecute in the interests of the United States. But our deep engagement is what mattered. That is, we couldn't have succeeded without having been involved on a day-to-day basis and getting to understand the mechanics of what took place. And very often, understanding that was more important than what we could actually achieve through the courts. And I think part of that contributed to the sense of the people who took part in dissent that the repressive measures really weren't going to work, that they could engage in this dissent, and it allowed the dissent to become the quite powerful force that it did become in the United States during that period, and it ultimately, I think, helped to defeat the repressive measures. So what I would say to you is, yes, by all means, look at the archives. By all means, look at the court decisions. But if you can find some of the people who actually went through the experience and you can interview them, you may get another dimension to the story.
I just want to say two very quick things. One, I have interviewed many of them, though not you yet. And two, you are a new constitutional historian, right? That's what we're saying is you want to look outside the big cases and outside the court records to see what's going on the ground, and that's exactly what you're saying.
I just want to amplify something that Aryeh said, because he left out one important dimension in this. The connection between the Southern Civil Rights Movement and the subsequent ACLU. Terribly important, absolutely important. I was there in Mississippi in 1964, Freedom Summer. By 1982, I'm on the national board, the ACLU. I was amazed at the number of people, staff, board, and the affiliates who had been in the South in the civil rights.
It didn't do that much for racial equality in the South, but it did an enormous amount for people who went south during that. It had a transformative effect on them.
I've used that very word to describe myself. It experience that changed my life. I forget exactly who said it, but it was one of the ACLU staff who said, people went south for the summer and never returned. And in metaphorical sense. But then, by 1985, I get this bright idea to write a book on the history of the ACLU, and so I can get into the archives and I get further documentation. Out there, I'm reading files of Al Bronstein when he was hired for LCDC, and he's got his mortgage payments, all this private stuff that's in there. But the part you left out is it had a powerful effect intellectually and from a policy standpoint. And I think it was Bert Newborn who really explained it to me. It was the experience of the Southern Civil Rights Movement got people to think in terms of what came to be called the enclave theory. I think it's actually in Tinker, but they used it for this.
We talked about schools, mental hospitals, the military, and prisons as enclaves in which civil liberties did not ordinarily operate. And our theory was we wanted to get civil liberties into those enclaves.
That's exactly the way Bert described it to me. You must have been at the same coffee at that point. But it had a tremendous impact in terms of what is a real shift in ACLU approach to civil liberties with these different groups and looking at them from a civil liberties standpoint.
Now, I'm looking anxiously at Elizabeth, who wants me to keep things on schedule, but I see three people. Can we?
Why don't we take these three? The reason I'm anxious for is that the next panel that we have, two of the participants really believe that that's and so I don't want to cut that short on surveillance and on our own section. So I don't want to cut that short. So let's do Janet and then maybe can we clump the two together and have a short break after that?
Thank you.
I have a question for you, Sam. I'm Ben Primer. I was the university archivist and curator of public policy papers, a person for a long time. But I want to, do you have any sense that for a long time the ACLU sent they bound up their records in a crazy way that nobody would do today, and they were at the New York Public Library. Do you know how they got to Princeton?
I don't.
Well, I've always speculated about this, but I do not know for certain. But I do know that the New York Public Library microfilmed all of these bound volumes, and which we eventually the two of us sold to places all over America. And my own guess is that the public library had decided that they were simply going to throw away all of these bound volumes. And somebody at ACLU or at the public library objected, and at that point, Firestone had just opened up. There was a lot of room, and so some decision was probably made, and my guess is that Julian Boyd, who was the librarian at the time, was approached about taking the ACLU archives, and so they ended up here. The plan was that the New York Public Library would continue to microfilm these year after year. That never happened, and at some point the ACLU just began to ship everything here. And then when I came in 1990 to the Mudd Library, I was concerned that we weren't getting, the ACLU wasn't sending us the records in a timely manner, and they weren't complete. So I went to the NHPRC for a grant to organize the ACLU records that were here, including those that had not been filmed. And at the time, the ACLU was located on West 43rd Street, and so we hired a woman named Janet Lindy to be the first ACLU to work on the organization of these papers in New York. And in addition, we hired a guy named Tom Roscoe, who now is the head of special collections at MIT. And basically what I said to Janet when she came, when we hired her, was I don't care about, I'm less concerned about the records and their organization. My concern is that you should work your way into convincing the ACLU that they needed an archivist, which Snow is now. And so it worked out very well. Then ACLU moved from West 43rd to downtown.
We need to, because we need to keep going.
I'll stop then.
Okay, thank you. Thanks so much. Yes, there's a lot here, so thanks.
Well, actually, the history of the ACLU archives, another subject, is not unrelated to what I wanted to comment, because we have had an archivist internally recently, so we have a much more reliable control over how things get to the archives. But that wasn't true in the early days. And I think what paper we have is somewhat serendipitous. I was saying this morning, maybe nobody kept a copy of some of those pamphlets that say ACLU on the front, but maybe they existed. And that brings me to Roger Baldwin. So when you were talking, Laura, I was thinking of the Ralph Waldo Emerson quote, "An institution is but the lengthened shadow of one man." The ACLU is not but a lengthened shadow of Roger Baldwin, even though he would have liked to think that. So Jeff Stone was saying at lunch that he's on our National Advisory Council, which has a very important role because we get to put on our masthead names like Jeff Stone and Whoopi Goldberg. So that is very important. But it is not true that, that Anthony or I get to make the policy. We have an incredibly democratic process through our board where they decide what we're going to do. And the same was true in Roger Baldwin's day. He wanted to do international work, and he was shouted down by his colleagues. But I think that if I were in the archives, this is where, I'm glad I'm not a historian, because I think that a lot of the early archives of the ACLU were controlled by the voice of Roger Baldwin. And when you're talking about direct action, I believe in labor, that's Roger Baldwin. The 12 Lawyers Report is very careful to keep at arm's length. We are not anarchists. We are just saying they have a right to say. And I think it's very hard to disentangle those because Roger Baldwin was so loud and so speaking for himself. So, that's my problem. Yeah, everything that you say is entirely right and is one story about what the ACLU was doing at the beginning. But some of that is because Roger Baldwin was pushing the envelope in his way. And he talked, as you're saying, he wanted more supporters. So he talked out of both sides of his mouth. Sometimes he was saying, I'm pro-labor, I'm a communist. Sometimes he was saying, we defend everybody. So I think those stories are complicated.
Okay, I'll just very briefly respond, which is, you're absolutely right. There's a sort of temporal dimension to this. So Baldwin was much more central prior to about 1927, 1928. He actually circulated a proposed expansion of the program or clarification of the program of the National Organization in 1929, and for the first time encountered resistance precisely because he had been so effective at bringing in other people, not just to the National Committee, but to the Executive Board. And at that point, and there were important vetoes and referendums for the entire organization over the course of particularly the late 20s and the 30s that moved things well beyond Baldwin's sort of control. But in the early period, it wasn't just Baldwin, by the way. It was Walter Nullis, it was Albert de Silva, it was many others. This was, I just want to emphasize, this was not just Baldwin's statements, which was true of, say, his yearbook entry on communism in the 30s, right? These were actually the statements that were made in official ACLU documents during the 1920s. And I think the story of it was just Roger Baldwin has led us astray in ways maybe that have sort of obfuscated the broader story of the labor origins of the concept of civil liberties itself, which is something I guess I can't.
Okay, I wasn't saying it was just Roger Baldwin. I think that you just hear a different tone. As I was saying, there's a very big cast of characters, and not everyone is on staff, and not everyone is even on the board. And there are other people who are spokespeople for the ACLU who take a different position.
Absolutely.
All right. First of all, Aryeh, you're Moviola. Now there's an app for that. The ACLU, we have an app that allows you to tape the police. It's been downloaded tens of thousands of times. It's a great tool. Laura, I was so fascinated by what you said about the labor movement in the ACLU. I think right now we're going through a shift where we are going a bit back to that. Just yesterday, so I'm the executive director here in New Jersey. We were out in the picket line with the 1199, the healthcare workers, showing our support for their right to a basic living wage. But I'd like to hear your thoughts on what led to that shift in the kind of the middle part of our history. And just one thing I'll say, every year the ACLU has an orientation for new staff, and sometimes I present, and I always use this one example from Roger Baldwin to talk about how our roots are actually not in litigation, even though I am a lawyer. And it's from Mark Tushnet's book about the NAACP's strategy to desegregate the public schools. And Roger Baldwin was one of the biggest critics of the NAACP's litigation strategy. Yeah. And he actually talked about how we're not going to win this through litigation. We have to build a movement, a solidarity movement with the people to show the workers are united and so forth. So how did we shift? How did we move so
It's a great question. It's the central question, actually, that I'm trying to address in my book, and to sort of very briefly sort of highlight the big events. So, the direct action strategy of the early 1920s was largely unsuccessful. A lot of the early cases had to do with preserving a space for distributing propaganda. So when we think of why is it that the ACLU was opposed to compulsory public schooling in Pierce v. Society of Sisters, despite the fact that progressives supported it, it was because they wanted to preserve a space for the Rand School of Social Science to disseminate, to have socialist education, right? Okay, by the mid-20s, they're starting to litigate cases, and they're successful at it. Also, there's a period of labor quiescence. So, after the failure of the great coal and steel strikes, and basically, the labor movement stagnates in the 20s under Republican administrations. There's a move away from this. They start to look at less controversial issues, things like sex education, things like artistic freedom, academic freedom, where they can build a broad coalition. They're very forward-thinking about this. They start to win cases, mostly on the state level and lower court levels. By the 1930s, they've been so successful at this that much of this is actually internalized, and they take up a court-based approach. And this is when the early leaders actually sort of get hung out to dry. In fact, you still have people hopping, in the great, famous case of Hague v. CIO, which is seen as this very important case protecting labor picketing, you get some of these early ACLU activists jumping up on cars and saying, "Arrest me." And you start getting internal correspondence saying, "That's not what we're about. We're a respectable organization. We bring our ideas to the courts." Now, so there's a component of sort of success. I guess I need to wrap up, but happy to talk about it.
Elizabeth, it's the hook. You've got the hook. Thank you all.